Start. Good.
Good morning, sir. Apologies for the faux pas. Let's begin. Let's redo the interview again, the introduction of the interview again. My name is Harsha. I'm currently in 5th year of the bachelor program. It's a great pleasure to have you here. I've been hearing a lot of...
Good morning, Harsha. It's lovely to be with you.
So I want to start by talking about your work at the conference here, where you spoke about the bridging rights and how recognition of fundamental right as a moral claim is important. It's different from enforcing the right. We need to have a right, fundamental right, and the mere fact of having, there's no need to recognize, to enforce a fundamental right, to have that right in itself. The idea that certain rights are not practical at this point of time does not mean you don't discard the existence of a right. Seems revolutionary in the conference because there have been multiple people asking you questions about it, and there are multiple deliberations over that particular issue and conception of bridging of rights.
Yes.
So how do you go about it, and what made you take that stance?
Yes. So I've been concerned with the situation which exists across the world in all rights contexts in a way, but particularly in the global south, where we have a situation where there are where we have rights, we have claims, let's say, to adequate housing in the constitution, and yet we have many hundreds of thousands of people who lack that housing. How do we move from a situation where people lack that housing to a situation where they actually have that housing, right? And what does it mean to say people have a right in that context? And that's the struggle that I had when I engaged with the paper, and the way in which I have you got light?
It's on.
Okay. So, the struggle between having a moral ideal, okay, and actually trying to instantiate the ideal. And one of the things that I decided and came up with was the notion that rights should be understood as a bridging concept. What does that actually mean? Rights as a bridging concept means that rights are moral ideals which place a pressure on societies to give them effect, to institutionalize them legally, right? And so my view is that on the one hand we do have rights which are ideal claims, but those ideal claims in many ways really have to find methods and means through which they're institutionalized. And this was part of the bridging idea, which then has major effects on the way in which I think judges and other actors in society give effect to rights, because it means that we have to attend very carefully to the structures that prevent the realization of the right and to the way in which those rights can be actualized. And we do have to also attend to the relationship between where we are now and where the ideal is. And it might well be that we have to take certain steps short of the ideal in the process of realizing the ideal. And so, for example, we might have to say, not everyone can get an adequate house now. We have to ensure everyone has a shelter from the elements which protects their dignity in the process of developing everyone to an adequate house. And the real question, and the hard question, I think, for societies like India and for South Africa, is how do we construct the bridge from where we are now in the status quo to a better society that's laid out in our constitutions, that outlines the ideals of the fundamental rights that require institutionalization. And for me, that's the idea of the bridge, of moving from here to a better reality with a thinking through the concrete steps that need to be taken in that process.
So you have clerked with Justice Langer during the hearing of the Grootboom case.
Yes.
My knowledge is that Grootboom case is exactly the opposite of you. They have tried to Judiciary has tried to enforce certain rights which were not practical for the government at that particular point of time. So are you going against the stand taken by the judges in the Grootboom case?
So the Grootboom case was a very important case in South Africa, which dealt with a group of people who landed up on a field simply with plastic sheeting to cover them in the driving rain and wind of the Western Cape. Many people won't know that, but it's a very unpleasant experience in winter. And so the question becomes very strongly, it became, what did the right to adequate housing mean for those people? And what the Constitutional Court in Grootboom said was that everyone has the right to the government developing a program relating to housing, and that program must be reasonable. Okay? And what the court said in that case is the government did have a program. It had a program which would provide everyone with housing in the next 20 or 30 years, okay? But the court said, what about the people on the field? The government had no answer to that people on the field. It said, you must wait. But people can't wait. If they're suffering right in the here and now, there needs to be some attempt to deal with the people's short-term needs. And so the court said that the government program was unreasonable because it failed adequately to deal with the short-term needs of people. It didn't balance short, medium, and long-term needs.
No.
Yes, would you like to?
Are you saying that the bridge here, you are talking about a bridge, what happens to the bridge here? The court clearly doesn't discard the notion of bridge here by saying it's short-term needs.
I don't think it discarded the notion of the bridge. In fact, I think the court considered the idea of the bridge because it realized that there's got to be a bridge to the future for people, right? If you just say people, 20 years we're going to provide you with a house, what happens to someone now? There needs to be some provision for someone now which enables them to get to the future, and that's part of that bridge. My critique of Grootboom is the reasoning of the court is based on a notion of reasonableness. It uses this doctrine called reasonableness, which I found a very vague idea, which fails to give adequate content to the right and fails to give people something clear that they can claim, which can also later on be used to guide policy and can be used to guide other judges. And so what I argued is that the court should have developed stricter and more contentful standards. And what it should have said in Grootboom really is that everyone has a right to a certain amount of shelter from the elements, and that is the basic standard from which housing development begins. And that is not the end of the right, but that's the beginning of the right. And from that, what we can call a minimum core of a right to housing, the government builds to ensure that eventually people have adequate housing. The difference is really in the way in which the court approached giving content to the right. And for me, in South Africa, where it was at the time and still is in some ways, it's very important to lay down principles which can guide other branches of government and the judiciary itself. And I think there's a similar, from what I've heard, in India there's a similar problem, that in many ways the right to housing, it's not been fully developed, it hasn't been properly articulated, and actually the articulation of the right and the giving of some content to the right would actually help the struggles of people to try and ensure that it be realized.
The work of the conference, researchers for the conference seems to have said that it's important to recognize that there's a distinction between right to housing and legal right to housing. The moment we go to the legal right of housing, there's a possibility, there's a plasticity involved the moment the right is concretized as a legal right.
Yes.
And there's a need to discuss about right to housing outside the law insofar as executive orders, not a legislation or a judicial order. What is your take on that?
So I think we should have a wide question around what the right to housing is. My argument, of course, is that the moral places a pressure to institutionalize and to legally institutionalize. And so my view is that we should, that large segments of the right to housing should be institutionalized, that they should be legalized. And I think there's always a worry that perhaps you become too concrete and you become concrete in the wrong way. My view is that actually what the right to housing should do, at least at the more abstract level, is it should set certain standards of what people are entitled to based on their fundamental interests in housing, for example, and this applies to other rights as well, that then allows us to then guide policies. So I don't think it will lead to the problem of being overly restrictive that prevents flexible policy development, which might be necessary in this area. So I think, on the one hand, you need the general constitutionalized right, legal right, which it provides a certain set of standards rooted in individual interests. Those standards will then guide the development of law, and those laws and also the enhancement of existing laws, and then policy responses which are all rooted in what people really want in relation to housing. And for me, that's ultimately what's important, right? We don't want to force people into certain situations, but people want a sense of what we heard in some of the panels: stability, security, privacy, a space in which they can develop, a space in which people can have partners and families. all of these things are important components of housing. We need to recognize them, and that can help guide the policies that actually the government implements.
So, how do you see the role of judiciary in this? You have written a book on poverty and fundamental rights, the justification and enforcement of socio-economic rights. How comfortable are you with the idea of judicial enforcement of socio-economic rights?
Yes. So that's one of the big questions that has been in this field, and many people have said, well, there are real problems with judicial involvement. Let me start by saying socioeconomic rights are not only for the judiciary. Socioeconomic rights are things that are rights which should guide other branches too. So the legislature and the executive has a real important responsibility to realize socioeconomic rights, and part of the power of social rights is to say to individuals in positions of power who often are more privileged, you need to consider those who are more vulnerable. Okay? So that's part of social rights. At the same time, I think we have different structures of government, and there are reasons why we have different structures of government and separation of powers, and the judiciary can play a very important role. We know in relation to fundamental rights that there is a reason we give judiciary often a power of judicial review, and we have to go back to those basic understandings of why do we have that power, and that power really comes from the fact that there are often problems in the democratic structures which lose sight of people's fundamental rights, and there's a thinking that the judiciary, from its particular aspects and particular features, can help correct for failures in the general democratic system. So there might be a failure, for example, homeless people may lack a strong political voice, and therefore the general structures of democratic structures fail to address homeless people's needs. Right? The question is, what do you do then? Well, you could organize homeless people, try and get other people to engage with homeless people, improve their standing, their way in which people engage with homeless people, and try and get more strong on the political agenda. That's important. I don't think it's not. But of course there is that case where that individual person is on a field, like we mentioned, with plastic sheeting to cover them, or a group of people, and they haven't got a whole organized social movement. Should we just leave them there? Right? So there's a blind spot in the system, and it seems to me then the judiciary has an important role to play. The judiciary is tasked with realizing fundamental rights. Judges should be schooled in an understanding of social justice, in an understanding of fundamental rights, and I hope that the law schools in South Africa and in India are trying to develop that kind of consciousness amongst law students, so that who will eventually become judges. And judges then have a particular expertise to make comments and to make judgments that relate to fundamental rights. That doesn't mean a judge, and this conference has brought it up, is an expert in everything. Right? And one of the main objections to judicial involvement is what's called the competence objection. Right? That judiciary aren't necessarily economists or housing experts, etc. But a lot of development in relation to social economic rights has shown that actually the judiciary can draw in that expertise often, or it can work with other branches of government. So it's not always necessary for the judiciary to say, absolutely, we're taking on it on ourselves to make a judgment on this whole area. What it can do, so one example I'll give to you is a case in South Africa where a group of people were living in the inner city in terrible conditions. The government wanted to move them out because they said the buildings were unsafe, but they wanted to move them 30 kilometers away to a space where the people didn't have any means of earning a livelihood, right? And this came to the court, right? And the government was approaching the people and basically saying, you have to move. It's unsafe, we're moving you. And the people were like, well, we don't really want to stay in these buildings, but if we move, we haven't got any means of earning a living because all our living is in the inner city, right? And what the court actually said in that case was, what we're going to require the government to do is engage with the people meaningfully, is to negotiate a solution to the problem. The court doesn't have to impose the solution. What it said is, the government, have to engage with the people because the people also want a solution. And together you can find some way to address this kind of issue. And in fact, the case led to a happy outcome, where the people stayed temporarily in those buildings, the government improved the safety of the buildings, but then the people actually agreed eventually to move to other accommodation in the inner city. And that was really an important ability to show like what a kind of negotiated solution could lead to. And these kinds of solutions are also possible to bring in expertise, that the court can ask for experts to give evidence in court. But not only that, sometimes it can say to the legislature, look, your housing program, like in Grootboom, is not acceptable as it stands. You go away and devise one that addresses these shortcomings and come back to us and tell us what you've done. There, the court doesn't determine housing policy itself, but it sends it back to other branches, and there's a dialogue and collaboration between the different branches to help ensure that the fundamental rights are realized. For me, those are good opportunities. They're part of democracy, and they show a way forward in which the judiciary can play an important role in realizing social rights.
So are you saying that the judiciary is supposed to move from the adversarial nature of the system? Because yesterday during the education panel, Professor Dhanda was talking about the problems of moving judiciary for all the cases because of adversarial nature of the system, of the current judicial system. So are you arguing for a shift in the judiciary from adversarial system to negotiations and deliberations for enforcing socio-economic rights?
I think there's an interesting question there, and there's a challenge to the way in which, certainly in India and South Africa, the way the judicial system is set up as a sort of very adversarial process, and sometimes that doesn't work very much for people who are very poor. I'm not necessarily saying that we always have to do away with, let's say, two sides presenting a case. But I think what often happens, the judiciary can play a role here in saying sometimes the solution isn't you win or you win. The solution is actually we've got a common interest in finding solutions to major social problems. How do we address the problem of malnutrition in South Africa? How do we address the housing crisis in Delhi, right? This isn't an issue of saying, well, the government's right or the people are right who are coming. The court, very importantly, one of its key roles is to listen to the litigants who come before it, right? And this is an important component, that they need to actually hear what the kind of struggles are and the problems that people are facing. And then the court can well say to the government, look, you can't ignore that either, right? It seems like the government's not doing its job. How can we find some kind of consensual solution? How can we stimulate social policy? How can we ensure that democracy works better by ensuring people who generally excluded are included in deliberations and in finding ways forward to address some of these social problems? So yes, I think that the way in which we conceive the separation of powers is to some extent challenged by the socioeconomic rights context, where it need not always be an adversarial process, but there's an understanding that there's really a common goal with different functions in some ways being performed, but a common goal to improve the conditions for ordinary people and particularly poor people.
We're in the last day of the conference, so do you have any takeaways and any suggestions for the researchers in finalizing the report, and how was the experience with the conference and the panelists?
I think this was an excellent conference. I think it was really, maybe one of the best I've been to. It was a conference in which we had a combination of activists on the ground, who I must say were very inspiring to me. Really moving in many cases. Activists on the ground. We had people involved in really policy areas. We had lawyers. We had people from other disciplines. We had economists. We had historians, all coming together to engage with real social problems. We also had, interesting enough, also celebration of like the art of people from the streets, celebration, engagement with theatre and vulnerability. So I think this conference was a very successful bringing together of a range of different dimensions, which I think together have to be part of the solution. So it seems to me that, of course, that's a difficult task. I haven't actually seen the report itself. I've only seen the executive summary. But I do think that there's a lot of important things there. I would encourage the researchers to think carefully on some of the feedback they've got in the conference, then to integrate that into the report, and then I think very importantly to release the report. I think to make an impact, that report needs to, on the one hand, have that academic rigor to it, but also, it seems to me importantly, the researchers need to play a role in advocating in the public sphere for some of the recommendations that are made. So, for example, I was just sitting in a panel on the right to housing. One of the recommendations is that it's important that there be a constitutionalized right to housing, which is given content. That is something which needs the building of a social movement and pressure to create. I think this report could be the academic base for actually pushing for real improvements in the political sphere in India and the judiciary to enhance the social rights of individuals. And I think a big study like this was really needed, and I hope that it will have a concrete effect in shifting and pushing for improved social provisioning, because it does sound to me like, from what I've heard the last few days, there does seem to be a bit of a crisis in India with, on the one hand, admirable democratic processes and social activists, and yet some kind of real malaise within the state of not recognizing that its role strongly is to ensure that vulnerable individuals are catered to. And how do we now, there needs to be a sense, I think, of a renewed common project in India. This is from an observer from without. I think it's true of my own country too. But a renewed common project to help address the real rights of people, because these are rights. They are central, important claims that every individual can claim. And we need to then have a realistic assessment of what are the obstacles and how do we remove those obstacles. So like I said, we can bridge the divide between where we are and where we're going to head to.
Thank you, sir. It's been a pleasure.
Thanks very much. Excellent.